Atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government, love.
Welcome to the Politics Guys. I'm political scientist Michael Baranowski, an emeritus professor at Northern Kentucky University. I'm joined today by political scientist Michael Levy.
Hey, Mike, how are you?
You know, I'm struggling a little bit. I got to say, between shows, as listeners know, we record this right after the weekend show, and I got the theme song to The Muppet Show stuck in my head, and it will not come out. So it's not good. I'll try to push through this, but I'm having some problems.
Being a man of the same generation as you, I have never seen The Muppet Show. Like, I've seen bits and pieces. I've not seen a full movie. Never one of my things.
You know, I got to say, first the whole soccer thing, and now the Muppet Show. I mean, you really are trying to destroy this country, aren't you, Michael?
One brick by brick.
There you go.
Marco Rubio might
you
say.
Do what you can. Anyway, so as I mentioned on the weekend show, there were a lot of things that we were hoping to get to. We didn't quite have time for, so we will just sort of pick up where we left off here. And we'll start with, Monday, July 13th, Judge Kathleen Williams, an Obama appointee, issues a 56-page order in Trump versus IRS. This is the case the president filed in January against, the IRS, the tax agency he runs. Trump had already dropped the suit back in May after settling, but 35 retired federal judges, none of them parties to the case, filed a motion asking Williams to reopen it, arguing that the settlement was what they called a fraud on the court. Now, that's a legal doctrine that lets a judge protect the integrity of their own courtroom by non-parties or on her own initiative with no filing deadline for those sort of claims. And so Judge Williams used that opening to rule that the lawsuit was never a real dispute and that Trump's side acted in bad faith. In fact, she referred one of Trump's lawyers to the Florida bar for possible discipline. She barred a second one from practicing in her court for a year, prohibited all parties from ever citing the deal as a settlement in any proceeding, and said that Trump's side may owe the legal fees of the former judges who intervened to kind of get this whole ball rolling. Now, a federal court can only hear a genuine dispute between opposing sides. And so Williams just said, well, there wasn't one here because, of course, President Trump controls both sides. He sued agencies he heads, run by officials he can fire, defended by a Justice Department he directs. And so in the end, Judge Williams concluded the suit was brought to put a court stamp of approval, in a way, on the settlement that created that $1.776 billion anti-weaponization fund and barred the IRS from auditing Trump, his sons, or his companies over past returns. Now, she didn't formally void that deal because that wasn't before her, but she forbade the parties from ever calling it, again, that settlement, and wrote that the audit immunity piece of it may violate a federal law against executive interference in tax audits. Now, a lot of folks on the left see this as a victory for the rule of law. The Justice Department, on the other hand, calls Williams a partisan judge who ignored decades of precedent and says there was a live dispute, they say, because Trump sought relief the government hadn't provided. So what do you think about this ruling, Michael?
So I was almost laughing a little bit about part of the case, which is how the judge cited a bit some of Trump's own legal reasoning around the unitary executive. So in the unitary executive cases, the Trump administration is making the case that as the head of the executive branch, he controls the executive branch, all agencies, and has the right to hire and fire. And the second level, when it comes to this case, then there is an adverse relationship because the president is acting in his personal capacity as a citizen, suing his own government. It seems to be that, Trump, as Trump is wont to do, he wants it both ways. And in this case, the judge wasn't having any of it. But one point I wanted to talk a little bit about is you in your intro. And I'm not saying that your intro was wrong because it was 100% correct. But you referred to her as a Democratic appointed judge. And that is true. But I also, think about John Roberts' lament around, we don't have Democratic judges and Republican judges or justices. We have judges, and I'm paraphrasing it wrong. But it's a sad state that we do have to call out who somebody was appointed by to give a little bit of context as to where they might be coming from. And I'm not some naive, 10-year-old studying Schoolhouse Rock, but we have good historical evidence of judges appointed by Democratic presidents who don't always support Democratic viewpoints, and Republican judges not always supporting Republican viewpoints. But in this particular case, this self-dealing was too much for this judge to overlook.
Yeah. And I think it really is important to make that distinction between the merits of the case and the actual sort of violation, what's called Rule 11 here. In this case, it means filing a lawsuit for an improper purpose. And those are two distinct issues, which is why she couldn't necessarily rule on the merits, or she couldn't, but she could rule on this, essentially. But, you're right. I think that point about the Trump administration being essentially kind of hoisted on its own petard by this, strong unitary executive theory, what makes it, in a way, even more difficult is there's an executive order that Trump signed, if you're following it, 14215, which prohibits any executive branch employee from advancing a legal position in litigation that's contrary to that of the president unless they have written permission from Trump or the attorney general. So in other words, that executive order forbids anyone in the executive branch for defending the government in a lawsuit brought by Trump as long as he's the sitting president. So that makes it even more difficult to hear the argument that the Justice Department is making for Trump and not just detach your retinas from rolling your eyes so much.
And one of the challenges that the Justice Department faces in this is that, we have Blanche, who he or his subordinates going into court and saying, yes, we have a deal, or in front of Congress, and yes, we have a deal not to advance this $1.776 billion settlement. If the parties were truly adverse, then Blanche can't speak for the president. The president would have to sign the deal. And so in this case, Blanche is acting as both Trump's personal lawyer and as the head of the Department of Justice. But I sort of think back in this particular case and how we got here is we're talking about an illegal leak of taxpayer information. And, the IRS had contracted out to Booz Allen Hamilton. Booz Allen Hamilton had a contractor. This contractor leaked Trump's as well as dozens or hundreds, I can't remember the number, of other taxpayer information. That person was prosecuted. That person was sentenced to jail. And that leak was wrong. But this remedy that the Trump administration, that Trump and his sons and his businesses were trying to negotiate with themselves or his personal attorney, the remedy is much worse because, as we talked about in the weekend show, Todd Blanche was the personal lawyer, although he referred to himself as President Trump's lawyer. As head of the Justice Department, he's no longer supposed to be President Trump's attorney. But as you said in the show, what's the difference? The government is Trump's government, so everybody must follow Trump's rulings.
But I guess I wonder on the leak of it, when you mentioned that the penalty or the remedy really is sort of disproportionate, doesn't really, given the leak, I would argue that even more than that, the penalty doesn't even, or the relief that was crafted, I guess I'll say, doesn't even make sense given what the offense was. Because if the offense was not, and this is really important, the offense was not that the IRS did some sort of nefarious thing with Donald Trump's tax returns and improperly charged him or audited him or anything like that. It was that some outside contractor was able to get information and leak returns. So the idea that the remedy would be somehow related to giving Trump and his immediate family protection from audits makes no sense given what. And so again, but that's because it's not that Donald Trump doesn't care, I don't think, about the unitary executive theory or constitutional construction or democratic accountability. It's about power. And it's about what is best for Donald Trump. And this is best for Donald Trump here.
Donald Trump has such a high IQ. He knows
the
everything.
Highest.
He knows the ins and outs of the unitary executive theory. Donald Trump's motivation is what is good for Donald Trump. And he doesn't like being audited by the IRS. He likes, I'll say allegedly, manipulating his tax returns and the value of his investments to get better tax treatment. And so there's a reason why businesses like Trump's that operate at the edges, to put it politely, at the edges of legality, why they want to avoid any audits or any potential litigation, because Trump has a history of skirting the law.
And it should be pointed out that prior to Trump, yearly IRS audits of sitting presidents were a standard practice. And Donald Trump has only been audited once by the IRS as president, and that audit wasn't completed before he left office, whereas Obama and Biden, every return they filed while in office was subject to that IRS audit. I mean, I think, honestly, it would be good to have a law that mandates an annual IRS audit of presidential tax returns, and there have been attempts to do this. There was one that even passed the House in 2022, but of course, it never stood a chance. And honestly, at that point, the Democrats were in charge. They weren't serious about it. That was political theater, because if you really cared about it, you'd do something like say, okay, we're going to pass this legislation requiring audits, starting with whoever wins the next presidential election, which would maybe make it at least a little more palatable. But it was just a political messaging sort of thing. But it's really too bad that we need a law about that in the first place when it was just considered a perfectly normal standard practice internally to the IRS to do that. And they've gone away from that for, I think, very obvious reasons here.
Mike, how many completely normal standard practices are we no longer abiding by? And
I've lost count.
This is just one of a laundry list. We could probably just, in the show notes, it would be about 42 pages of all of the standard things that are no longer standard.
That sounds unfortunately about right. Well, why don't we move on then? Recently, Secretary of State Rubio said that the United States, we got a new mission. We are going to try to dismantle the International Criminal Court brick by brick, if necessary. And he did this a number of ways. He had a Wall Street Journal op-ed. There was a video, a State Department press release promising what the department called a government-wide campaign to systematically disable the court's ability to operate. Now, this U.S. campaign against the ICC, it involves a number of things like sanctions on ICC judges and staff, visa bans, travel bans, pressure on other governments, especially those that host U.S. troops or rely on U.S. security, to repudiate the court's authority and to cut off its funding. And so the argument for this is essentially a jurisdictional one. Rubio says the court claims that the power to prosecute Americans who never consented to it, and this power, therefore, threatens U.S. sovereignty. And he talks about Border Patrol agents, Marines, prosecutors as people who could, at least in his telling, someday be hauled before what he's called unaccountable foreign judges. Now, critics say the sovereignty framing, that's really more about impunity for U.S. actions. And the U.S. did sign, but it did not ratify that 1998 Rome Statute that established the ICC. And from the beginning, the U.S. has argued that, therefore, it does not fall under the jurisdiction of the ICC. But under that Rome Statute, the ICC can exercise jurisdiction when crimes are committed, or at least alleged crimes, are committed on the territory of a state that has signed the statute, regardless of whether the alleged perpetrator is from a signatory country or not. So, Michael, why do you think Secretary of State Rubio is making such a cause out of destroying an organization that the U.S. isn't even part of?
It's a great question. And I want to grant
bored?
The strongest version of Rubio's. Yes, you only ask great questions, but I want to grant the strongest argument for Rubio. I mean, and you talked a little about some of this. I mean, the U.S. never ratified the Rome Statute. The U.S. is not a member of the International Criminal Court. And I understand the concern that American troops, intelligence officials, Border Patrol agents, or prosecutors, the U.S. government not wanting to see them hauled before an international tribunal on potentially flimsy or politically motivated theories. So, I think sovereignty is a real issue, and so I don't want to discount that. But that's not really what launched this. And this didn't start with some abstract debate about American sovereignty. It really started with Israel. And in November 2024, the ICC issued arrest warrants for Benjamin Netanyahu and Yoav Gallant over alleged war crimes and crimes against humanity in Gaza, including starvation as a method of warfare. And Trump's own executive order sanctioning the ICC makes the trigger explicit, accuses the court of targeting America and our quote-unquote close ally, Israel. So when Rubio talks about protecting Americans, I buy that, but I don't want to lose sight of where this campaign started. And what the inclination is. It's to shield powerful states. I mean, people talked about the critique of Nuremberg after World War II as victor's justice. And if we look at the ICTR, the Criminal Tribunal for Rwanda or for Yugoslavia, it's typically been powerful countries bringing into the dock those who've committed war crimes in less powerful countries. And it's very unlikely that the ICC would succeed in, if the U.S. was accused of genocide. It's very unlikely that the International Criminal Court is going to be able to arrest and have extradited American president. But what I worry about is Rubio's not criticizing one prosecutor, one case. And when he talks about dismantling the ICC brick by brick, he's describing a world where law applies only when power allows it to apply. Yeah. And so what I'm worried about is as he dismantles brick by brick, when the building is gone, my fear is that the only thing left standing is power, which is probably music to the ears of people like Stephen Miller.
Yep. We hope you enjoyed this preview of our supporters-exclusive midweek show. If you'd like to hear the rest of the episode, we hope you'll consider becoming a supporter. Supporters get ad-free access to all of our shows, membership in our Politics Guys Discord group where you can join in on the conversation, and other benefits at different levels of support. To become a supporter, go to patreon.com/politicsguys. You can also support us through Venmo or @politicsguys or through PayPal. You'll find all of our support links in the show notes as well as at politicsguys.com/support. And if you'd like to get the midweek show, but you're not in a position to become a financial supporter, that's not a problem. Just send me an email at mike@politicsguys.com, and I'll be happy to get that set up for you.
This podcast is part of the Democracy Group,